It's December, gang, which means the fall Thunderdome has ended and it's time to suit up for the winter Supreme Court Quackdown. Will Justice Sotomayor break out her famous pile driver against the lawyer for Sony Music Entertainment? Will Linda McMahon revive her Y2K feud with Triple H and Clarence Thomas? We will find out in the ring. Happy Monday, everybody. I'm Brino, and this is the Morning Report on the federal courts for December 1st, 2025. Double tap your screen, comment who's going to look best in that championship belt, and watch the first minute right now, even if you're coming back, so we hit the FYP. Now, I had 4 stories for you this morning, but one of the Supreme Court cases today is important enough and complicated enough that it just took up too much time. So we're going to stick to the cases that the court's going to hear today. I'll fill you in on the other news tomorrow. And as usual, I will be going live at 10 a.m. along with the court to hear oral arguments on these cases, which is coming up pretty soon. So let's get to the news. Our first case in oral arguments today is Cox Communications v. Sony Music Entertainment. This could have some blowback for all of us, so I would listen up here. This is a case about copyright violations, and we're talking about digital downloads, Pirates Bay, that sort of thing. And the question here is about how responsible your ISP, your internet service provider, is when you decide to download something illegally. So, according to the record here, if I, Brino, have a Cox internet account, and I try to download the classic film Howard the Duck illegally, Cox will likely notice and they will stop me. Cox says that of its 6 million customers, about 57,000 of them were identified infringing on copyright, and Cox stopped all but a few thousand of them. But what about those few thousand that weren't stopped? Well, they were mostly a special kind of customer. Colleges, businesses, hotels, customers who only had one account with Cox, but hundreds or even thousands of users on that account. And according to Cox, it just wasn't worth tracking down which one of the thousands of students at the university or which single guest in a hotel was downloading something illegally, so Cox gave up. Well, Sony, who owned those copyrights, was not amused. They said that because Cox knew about this copyright infringement and intentionally did nothing about it, this was a willful act, and that's a key word. And Sony says that Cox's material contribution to the copyright infringement itself made them liable. So under 17 U.S.C. 504C, they are financially liable for the violations of those customers who they decided not to stop. And the lower court agreed, granting Sony a $1 billion judgment against Cox. Cox says that unless they affirmatively fostered or intended to promote copyright infringement, they didn't materially contribute to it. And more broadly, they shouldn't be held responsible for their users breaking the law. They're basically selling a utility. A water company isn't held liable if you drown someone in it. Now, you may hear references to a Gershwin case from 1971. Basically, there was an organization that put on concerts around the country, and the artists who performed would sometimes play copyrighted music. And this was a lower court decision, but it still cited a lot. And it said that the organizers of the concert were liable for the copyright violations. They knew the artists were infringing on copyrights. They provided the platform for them to perform anyway. They contributed to that infringement. But beyond that, there's not a huge definitive case in this area, and none of the justices seem to have a really obvious dog in this fight. So, Also, honestly, do we really care about which of these two massive conglomerates walks away with $1 billion here? Well, this decision could put a big burden on our internet service providers at our homes to monitor what we're doing and make sure we aren't infringing on anybody's copyright, which could cut pretty seriously into our privacy. And since companies like Sony aren't likely to recoup much money from going after individual violations, this case is more likely than not to start spawning new cases where they hit up all of the ISPs, and it probably won't just be Sony. So our privacy could go down and our costs could go up all in one fell swoop here. Okay, now we are going to look at Urias Orellana v. Bondi, which is probably one of the most important cases this term, but it's mostly been overlooked by the media, so really pay attention to this. This is an immigration case, but has a really wide reach. And to understand this, I need to go over a few things first. Okay. First, we got to talk about Chevron, the Chevron doctrine. I'm just going to do a shallow dive here because it's complicated. So Chevron said that a federal judge must defer to an agency's interpretation if one exists. That means that if Congress wrote a law banning dangerous pesticides, and the judge wants to know if this pesticide is dangerous or not, the judge should defer to the EPA's answer on that question. The judge should not try to interpret it himself or herself if the EPA has weighed in. And the EPA is the agency that handles all the pesticide stuff. They hire experts who know a ton about pesticides, just judges do not. So this rule sort of made some sense. But it was overturned this past year in a case called Loper Bright. Very important name. So the new rule is that judges can defer to what the agency says, but they don't have to. Okay, that's Chevron. More importantly, it's post-Chevron. Federal judges don't have to defer to agencies anymore. Okay, second, we all need to be on the same page about the lawyer's definition of the word fact. And you may have already seen one of my videos about this, but let me make sure we're perfectly clear. Every question in the legal world is either a question of law or a question of fact. And if you can answer a question using your senses, your eyes, your nose, that's probably a fact. Is the car green or blue? After listening to testimony, is this witness believable? Does it smell like duck ass in here? There we go. The answer to these questions are facts. And we don't really care if these little tiny items of information are true or not. And here's why. You probably remember that two people can look at the same picture of a dress and completely disagree as to whether it is blue or white. Both people are certain they know the answer, but they have different answers. So which one is true? Well, what if our case turns completely on whether the dress was blue or white? How do we deal with that? Well, we pick 12 random strangers off the street and we ask them. We call them a jury, or the finder of fact. And in a courtroom, we all agree up front that whatever they say will be our facts. And it doesn't matter if I still see a white dress. I agreed to accept the jury's answer, and they said blue. And the thing about a finder of fact is that nobody is allowed to challenge their answer. Now, appeals courts will argue about the law all day, every day. But if a jury decides the dress was blue, the appeals court won't challenge that, even if they're certain that it's white. So, facts are the set of details that make up the storyline of a case. She walked down the stairs in her blue wedding dress. Laws get appealed, facts generally don't, because a jury is a constitutionally mandated finder of fact. Last thing before I run through the case. In this country, we have Article 3 courts. These are normally, these are like the judiciary branch courts you usually think of. They're created by Article 3 of the Constitution, so Article 3 courts. But we also have Article 1 courts. Article 1 is Congress's article, and sometimes Congress needs a little mini court to collect facts, apply law, make some decisions, so they create these cute little legislative courts. But legally, Article 1 courts, such as immigration courts, are more like agencies. That word's back already. Okay, so now let's run through the case, but just keep these three things in your mind. Immigration courts are not technically judicial courts, they're more like agencies. Facts are different from laws, and they're decided by a finder of fact. And the Chevron doctrine, where courts were required to defer to agencies, has been overturned. Okay, so now the story of Douglas Humberto Urias Orellana and his wife and child. This story is kind of bonkers and almost a bit of a telenovela feel. So, on today's episode of Los Amores Clandestinos, back in El Salvador, there was a professional hitman. And Douglas, our main character, has a half-brother who got into a big fight with this hitman because the hitman's mom was dating the dude's dad, and they started fighting about it. And it started an all-out war. And two of Douglas's half-brothers were popped. Douglas was beaten pretty badly, the family had to move a couple of times, but the hitman, or at least his goon squad, kept following them to these other cities. So eventually, the family fled to the US and sought asylum as refugees. Now, a refugee is someone who either has been persecuted or has a reasonable fear of persecution, which means they have a fear and it's reasonable. So they can't be scared of Sharknado attacks. But this is a very fact-based inquiry. Is the story true? Are they actually afraid of the Sharknado? So, tell me what happened. I'll use my eyes and ears to decide if I believe you. And our finder of fact in this situation is the immigration judge, an Article 1 judge working for an agency. So, this judge decides the facts, then applies those facts, your story, to the law and decides whether you meet the requirements to be a refugee or whatever you're applying for. And if you do, you'll probably get asylum and you'll get to stay. Well, Douglas told his whole story to the immigration judge, and the immigration judge believed every word. The judge was very clear about that. I believe Douglas. But the judge still didn't grant asylum because the judge didn't think that Doug's story, even if it's 100% true, rose to the level of persecution to make him and his family refugees. And the Board of Immigration Appeals, also an Article 1 court, agreed with that immigration judge. So Douglas took his case to an Article 3 Court of Appeals, which the law allows him to do. But the Article 3 judges looked at this and said, both an immigration judge and a BIA panel agreed that this wasn't persecution, and they probably know more about immigration than we do. I think we are required to defer to their judgment on this. Required to defer to an agency. Sound familiar? So the primary question in this case is, does the Federal Court of Appeals have to defer to the BIA's decision that these undisputed facts do not demonstrate mistreatment severe enough to constitute persecution? Or can the Federal Appeals Court decide for itself whether Douglas's facts make him a refugee? And remember one more thing. The Trump administration has been insisting for months that federal courts cannot review its immigration decisions. But what is an immigration decision if not an agency decision? Didn't Loper Bright address this directly when it overturned Chevron? Well, I suppose we'll find out today. And that is your morning report on today's Supreme Court Quackdown. Quick thanks to Bill and Greg for the Venmo support. Please consider subscribing below or check out the link in my profile to help me stay sustainable. And I will see you all at 10 for a new round of Supreme Court Madness. Thanks, everybody, and hope you had a fantastic Thanksgiving.